The House Elections Committee will come to order. Will the clerk please take the attendance?
Chair Cerniglu.
Here.
Representatives Wagella. Here. Hope. Here. Colazar.
Here.
Burns.
Here.
Churches.
Present.
Smith.
Present.
DeBoyer. Here. Madam Chair, you have a quorum.
Thank you, Mr. Clerk. Representative Smith makes a motion to adopt the minutes from the October 24, 2023 meeting. Without objections, the minutes are adopted. For today's agenda, we will have testimony on Senate Bill 529. We will now hear testimony from Senator Moss on Senate Bill 529. Welcome, Senator Moss.
Thank you, Madam Chair, Vice Chairs, members of the committee. I appreciate it. It's good to be here in person. And I'm excited that you are taking up Senate Bill 529. So Senate 529 comes to us really compelled by federal action, recent federal action, and it makes Michigan compliant with the recent updates to the Federal Electoral Recount Reform Act. We all endured the 2020 election cycle, and I think we're beginning to unpack exactly what happened in the post-election period of that election cycle. And I think we now know that unlawful actors here in Michigan tried to obfuscate the certification process, and their plot failed, but spurred bipartisan congressional action to ward off chaos in future elections. So now it's compelled us as a state to strengthen Michigan's election certification procedures, to uplift Michigan voters, and disavowed some of the theories that came out of 2020. Senate Bill 529 would detail the ministerial duties following the presidential election to ensure that the winner of Michigan's presidential election is the certified recipient of the Electoral College votes that our state sends to Congress. This legislation clarifies the procedures and timeline for casting and counting the Electoral College vote.
Excuse me, sorry, could you? Thank you.
By detailing some of the items on our timeline here in Michigan that match where we need to go federally to certify and submit our Electoral College votes to Congress so that they can count it by January 6th. So the things that we are putting into our Senate Bill 529 includes mandating that the governor issue a certificate of ascertainment of appointment of electors not less than 6 days before the electors convene in December following the election. This clarifies that it is the governor who sends forward the state's slate of electors and addresses the potential for multiple state officials trying to send Congress competing slates. It shortens the time frame for the Board of State Canvassers to complete their canvass to announce the board's determination from 40 days after election to 20 days to ensure that the governor can issue that certificate of ascertainment in time. And it requires a ballot cast by an eligible elector shall not be rejected or not counted on the grounds that an election official failed to comply with a mandatory directive. This would ensure that eligible voters don't have their ballots invalidated simply because of mistakes from election officials. I am bolstered in testimony by, I think, some folks who are on Zoom who helped to actually craft the federal law. So some of the technical questions I can try to field, but they were the experts on helping this federal law move, and now they're trying to make sure that each state is compliant with it, which is why we have this bill before you today. So I can take any questions from committee members.
Thank you, Senator Moss. I believe we also have a sub. Do you want to go ahead and address that?
Yeah,
right
so
now?
while we were in the act, there are other proposals that we've been fielding and trying to bring forward through the process. So right now, the Board of State Canvassers, the nominees for appointment are decided by the governor, and the appointments or the nominees are presented to the governor, 3 from the Michigan Republican Party and 3 from the Michigan Democratic Party. We're expanding the list of nominees to include the legislative leaders from the Republican Party and the Democratic Party from the legislature to each submit 2 additional nominees. So the governor would select from a field of 5 chosen by the party and the legislative leaders from both parties rather than just party officials.
Thank you, Senator Moss. Do we have any questions? See no questions. Thank you for your testimony.
All right, simple enough. Thank you.
We will now have virtual testimony from Lata Knott from Campaign Legal Center. Welcome.
Hello. Thank you.
Ms.
Good
Knott.
morning, Chair Cerniglu and members of the House Elections Committee. My name is Letha Knott, and I'm an attorney at the Campaign Legal Center, a nonpartisan, nonprofit organization dedicated to protecting and strengthening democracy across all levels of government. And I am testifying on its behalf in support of SB 529. SB 529 will align Michigan law with the recently passed bipartisan federal law, the Electoral Count Reform Act of 2022, or the ECRA. Michigan should take swift action on this bill to ensure that its canvassing and certification processes are in compliance with new federal law before the 2024 presidential election. The ECRA updated the Electoral Count Act of 1887, or the ECA, and for more than a century, the ECA set the timeline for states to select presidential electors and transmit their votes to Congress. However, until the ECRA became law in January of this year, the original text of the ECA had not been updated since it was enacted, which was more than 130 years ago. That outdated statute was therefore pretty rife with ambiguities that left the presidential election process open to potential manipulation. That's why CLC was deeply involved with the bipartisan effort to pass the ECRA and is now working with states across the country to help them comply with the new federal law. And while the majority of the ECRA addresses the process by which Congress counts each state's electoral votes, there are a few updates that require Michigan to take action to bring its law into compliance with the new federal standard. The ECRA provides that each state's executive, in Michigan's case, that's the governor, must certify their state's slate of electors 6 days before the presidential electors are scheduled to meet. In 2024, the electors will meet on December 17th. Meaning that Michigan's slate of presidential electors must be certified by no later than December 11th. Currently, Michigan allows for the state canvass and certification process to stretch beyond the new ECRA's deadline in certain circumstances. The new certification deadline set by the ECRA is 36 days after Election Day. Yet, as it currently stands, Michigan's Board of State Canvassers is required to complete the final canvass not later than the 40th day after the election, which puts the state in jeopardy of missing that certification deadline. SB 529 would update the canvass procedure to require the Board of State Canvassers to announce their final determination within 20 days of the election, which would give the state time to complete post-election processes and certify by the ECRA deadline. It also clarifies that canvassing and certification are non-discretionary duties, and that boards of county and state canvassers must certify the results of elections based solely on returns. That aligns with the law with the Michigan Constitution, and it ensures that the will of the people will be respected in elections. Also, current Michigan law requires the governor to certify results as soon as practicable after the state board of canvassers has determined the outcome, but it doesn't specify precisely when the governor needs to certify. This bill would align Michigan's election code with federal law by requiring the governor to issue a certificate of ascertainment for a slate of presidential electors as soon as practical, but no later than 6 days before the presidential electors are scheduled to meet. That provides a clear deadline for all future governors of Michigan that they must follow and ensures that the state will meet the ECRA certification date regardless of who is in power. And this bill also lays out a clear process for issuing the certificate when other post-election processes like recounts are still taking place, helping to provide clarity and a clear course of action in all circumstances. Taken together, these updates will eliminate any ambiguity in current Michigan law and ensure that the state can comply with federal law. By passing this bill, Michigan would join a group of states such as Colorado, Indiana, Kansas, and North Dakota that have already enacted legislation this year to align their timelines for presidential elections with the new procedures established by the ECRA. This bill would allow Michigan to do the same. For these reasons, the Campaign Legal Center respectively requests that you support SB 529. Thank you.
Thank you. Do we have any questions? I see no questions. Thank you so much for your testimony. We will now have testimony, a virtual testimony from Kevin Johnson from the Election Reformers Network. Welcome, Mr. Johnson.
Chairperson Cerniglu, thank you very much. And thank you to the vice chairs and to members of the committee. It's a great opportunity to speak with you in support of SB 529. My name is Kevin Johnson. I'm the executive director of Election Reformers Network, a nonpartisan organization dedicated to advancing reforms to protect our democratic institutions in this era of increasing polarization. SB 529 advances the important work begun in Congress with the passage of the Bipartisan Electoral Count Reform Act in December 2022. The Electoral Count Reform Act focused on two very important goals: removing any ambiguity over the procedures that determine presidential election results, and ensuring that courts are the primary venue for judging contested elections. Congress fixed dangers arising from the ambiguities of the prior law, including that a state legislature might assume it could declare an election to have failed and decide on its own the slate of electors to represent the state, or that members of Congress could assume grounds for objection to state electoral votes beyond narrow limits appropriate to their role and to federalism. Scenarios such as these were described by one scholar as a loaded weapon lying around in our election system. Thankfully, those weapons have now been disarmed. Taking up the task of adjusting Michigan election law to meet the new federal law has come during a period of tight deadlines and multiple priorities for this committee and its counterpart in the Senate. Despite that context, SB 529 admirably addresses all of the key challenges. It precisely mirrors the language in the federal law to describe important new details of the results communication process. It provides certainty regarding a range of scenarios, for example, for correction of a certificate of ascertainment following a change in results from a recount. In keeping with Proposition 2, it ensures the purely ministerial role of state and county canvassing boards, echoing the emphasis in the federal law on courts as the proper venue for judging challenges and objections to elections. There is one minor kind of technical modification that my organization, and I believe CLC and Protect Democracy together, will all recommend, which is an edit to a non-substantive clause in a way that would reduce any potential tension between state and federal law. We will share that feedback on that clause with the committee staff. But in the main, SB 529 would make Michigan a leading state in terms of advancing the important goals of the Electoral Count Reform Act. I'm honored to encourage it to pass. Thank you.
Thank you, Mr. Johnson. We have a question from Representative DeBoyer.
Thank you, Chair. Just very quickly, do you see any conflict or perhaps the opposite, giving me the supporting position that the federal legislators or law being imposed down at the state conflicts with the provision in the Constitution that provides for the legislature to determine, the time, the manner, the place? And in fact, courts have decided that that's expanded much beyond that. That's just the baseline perspective. But the legislatures have the determination on how things are determined with regard to election process, beginning to end. Courts have been very, what's the right word, liberal with the width by which that applies. Just give me your take on whether you think this conflicts with that to some degree or it is supportable by that, if you don't mind.
Yep. I take that as a question to both of us. And I direct an organization, but I'm not myself an attorney. So I think Lada Knott maybe can lead. I think I will say generally, my answer is that I believe that both the federal law and SB 529 appropriately follow the core guidelines, which is that the Constitution gives Congress the right and responsibility to name the date of the election for the president and vice president, and it's anchored on that date-setting function that the whole electoral count process continues from there. And then, so this is an appropriate extension or discussion based on how to ensure that the election takes place appropriately under that congressional authority, and then handing to the states the specifics of the implementation. Lada, you can probably explain what I'm trying to say a bit better, but that's my overall point.
So, if I may, Chair.
Sorry.
Oh, I'm sorry.
We can have
To
that.
elaborate
person.
on what Kevin said, I agree. This is not a conflict between state and federal law. It is correct that states set their own election procedures, and that is been respected by courts, that states have that authority to set specifics about elections. And the ECRA actually says that in determination, like say the executive who has to certify the slate of presidential electors, it's up to the state to set that. There needs to be some a law in place, in our opinion. There needs to be clarity in those procedures, but there's no dictation as to who the proper executive should be, or different things in the process that a state uses to run its own elections. The ECRA just says you need to have this decided by the state 6 days before the electors meet. And it also posits the date that the electors are supposed to meet. And that in of itself doesn't conflict with the state's authority to run its own elections, to have its own election laws and procedures. This is just saying that when you're sending your slate of presidential electors to Congress for this federal procedure of selecting the president, you just need to have it done by the state. And you can see the importance of that, of course, is that in order to actually pick the president and vice president, you need to have a set date where everyone needs to send their electors. So I'd say no, there's no conflict there.
Okay, so I just want to make sure. So the Supreme Court, quoting them on election cause and expansively and enabling them to the states, it said, quote, to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registrations, supervisions of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers in making the publication of election returns. So I just want to make sure that I understand that this statute that was put into place by the federal government that we're going to try to comply with in no way violates that coming at us as a state.
No, I mean, it in no way violates Michigan's rights to run its own elections as a state. It just sets particular deadlines for processes where a state does choose its own slate of electors, but the process of the electors voting for president is a federal process.
Thank you. Do we have any other questions? All right, thank you. And we will now have testimony from Erin Shore from the Department of State. Welcome, Ms. Shore.
Thank you, Madam Chair. Thank you, committee members. It's good to see you today. I don't think any of us in this room will ever forget where we were on January 6th, 2021, when we learned that armed civilians had breached the U.S. Capitol building in an attempt to stop a joint session of Congress from certifying the results of the 2020 presidential election. That attempt was motivated in large part by questions that circulated widely in the preceding weeks, questioning the integrity of elections in several states, including Michigan, fostering doubts about the rightful winner of the presidency, and ultimately sowing misinformation about the legal proceedings that we use to select a president in this country. While democracy held that day, our federal representatives recognized the need to update the 1887 law that, as you heard, previously governed the counting and the meeting of the Electoral College. The new law establishes timelines and clear guidance for states to follow in appointing their presidential electors, and it requires states to update their laws concerning the appointment of presidential electors to bring them in accordance. Senate Bill 529 will do just that. You've already heard several of the highlights of the bill, as well as changes within the substitute to clarify the role of canvassers and their ministerial duty. I'm happy to take any questions and happy to be here in my support for Senate Bill 529.
I don't see any questions. Thank you, Ms. Shore. We now have testimony from Erica Pearsman from Promote the Vote, and I believe that's virtual as well. Welcome.
Thank you. Thank you, Chair Cernoglu and members of the committee for having me today. My name is Erica Pearsman. I'm Senior Advisor to Promote the Vote, a coalition organization that promotes voting rights in Michigan. PTV definitely supports Senate Bill 529. As others have stated, the Electoral Count Reform Act is a significant advance in federal law that ensures that the will of the people is respected in the presidential election, and it is important that Michigan be in compliance with the Electoral Count Reform Act, and that our election laws clearly state what the responsibilities of the governor are with respect to that act. And this bill lays out what those responsibilities are in detail and tells the governor exactly what she needs to do and when she needs to do it. And of course, what governors in the future need to do. It's also important that in the very unlikely event that a recount changes the result of the presidential election, that the governor and the affected candidate have clear direction on how to proceed. The last thing that we want in that situation is chaos when people do not know what to do and that there is any uncertainty about how to proceed. This bill does all of these things, which of course need to be in place for 2024 when we have a presidential election coming up. The PTV is grateful to the legislature for all of its work on this bill, which we know was not easy. It is not easy to marry a complicated federal law with Michigan's law relating to both the canvassing, recounts, and other parts of our election laws. And while there may need to be some fine tuning in the future, this bill gets done what needs to get done, and we urge the legislature to pass it. In addition, PTV supports the changes that have been made in the sub, expanding the pool of nominees for the Board of State Canvassers, gives the governor more options for this very important role. And we also support the adding to the statute the constitutional language with respect to the ministerial duties of both the Board of State Canvassers and the boards of county canvassers. It is extremely important. Although that language is in the Constitution, we definitely support it being in the statute as well, so that it's very, very clear that those boards have a duty to certify our elections, and that there is absolutely no confusion about that. So for all of these reasons, Promote the Vote supports this bill. Thank you very much.
Thank you, Ms. Perisman. Do we have questions? I see no questions. Thank you for your testimony. I have some cards now to read. We have Marissa Kovach from ACLU of Michigan supporting the bill. We have Sherry Ritchie from Michigan Fair Elections, Pure Integrity Michigan Elections, Stand Up Michigan, and the Freedom Alliance Project opposing the bill. We have Stephanie Zymus from Secure Democracy in support of the bill. We have Ricky Bicknell from Voters Not Politicians supporting the bill. We have Matt Patton from Protect Democracy supporting the bill. We have Andy Craig from Rainey Center Freedom Project supporting the bill. Now, Representative Wagella makes a motion to adopt substitute H1 to SB 529. Mr. Clerk, please call the vote.
On the motion to adopt the substitute, Chair Cerniglu,
Yes.
Representatives Wagella,
Yes.
Hope,
Yes.
Colazar,
Yes.
Burns,
Yes.
Churches,
Yes.
Smith,
No.
DeBoyer.
No.
Madam Chair, if 6 yeas, 2 nays, 0 passed, the substitute is adopted.
Thank you, Mr. Clerk. Representative Hope makes a motion to report SB 529 with recommendation as substitute H1. Mr. Clerk, please call the vote.
On the motion to report, Chair Cerniglu,
Yes.
Representatives Wagella,
Yes.
Hope,
Yes.
Colazar,
Yes.
Burns,
Yes.
Churches,
Yes.
Smith,
No.
DeBoyer?
No.
Madam Chair, you have 6 yeas, 2 nays, 0 pass. SB 529 is the fourth recommendation, substitute H1.
Thank you, Mr. Clerk. There being no further business before the committee will stand adjourned.